All right, welcome back to For the Record. In case you're joining us, we are in the middle of this trial. Second witness or third witness testifying. It's moving very quickly. Latonia, let me ask you a question. In the opening statements, the prosecutor brings out that the defendant said that the driver's side door would not open, so he had to go out to the passenger side. While that happened, the cop was going around, the sergeant was going around the back of the vehicle. The prosecutor arguing giving the defendant tactical advantage to shoot the police officer 6 times, then got on a radio saying that the person's in custody and they're going back to headquarters. In my mind, the reason that this is being done is that there is an argument that the defense has raised previously, whether it comes out now or not, we don't know, that there's a mental health history here, showing that the defendant was doing things that were very, very purposeful, up to and including about a month before, saying if he ever got pulled over, he was going to take out the cops. Really, really bad evidence for the defense to prove it, no?
Without a doubt. And it shows something where it's calculating. It's something where it's not necessarily a defect that's going on, that you had a thought process about if you were stopped and you executed that on some levels, and on some levels you did an execution. So I think that's what the prosecutors were doing, making sure you knew that this was purposeful what he did. He made sure that he got the officer in a vulnerable situation so that he could get his gun out, so that he could be able to shoot him. And then I just thought that it was a very powerful opening, being able to talk about exactly what happened to the officer on that day. It was powerful and very disturbing.
Mike, I can't help but look at the differences about how these trials unfold. And in particular, I was thinking of the Chauvin case and thinking of the Durst case. In the Durst case, especially, like, hey, throw everything out there. But here there was a legal argument over whether or not the 911 call that initiated this whole process, where one of the people is giving an excited utterance, as they say, something close in time, where they're stressed out, is inherently reliable as an exception to the hearsay rule. At least in New Jersey, this would be something, and we're pretty conservative compared to the other cases I mentioned as far as our evidence rules are concerned. This is something that typically would get out, not for the truth of the matter asserted, because that's what you have to show that's hearsay, but to show why the officers responded in the manner in which they did. This judge seems pretty seasoned. Why do you think he excluded the prosecution from admitting, but otherwise in those other 2 trials, there's no question in my mind it would have come out, and even in Jersey it would have come out? Why did he do that?
Well, I think one of the reasons, Bob, is that this appears to be a trial that has overwhelming evidence, meaning like a piece of this evidence with the 911 call, whether it comes in or not, I really don't think is going to change the jury's conclusions or affect it that much. So I think this judge seems to be a judge who, before he got on the bench, spent time in the courtroom and tried cases, is being practical. He's ensuring that no matter what happens in this case, that any appellate court will look at it and say, this defendant got more than a fair trial, and there were anything that's going to a close call of admissibility that could hurt the defendant, it looks like he's going to keep out because there's so much solid evidence that you don't have to get in there. And I compliment the judge for that, because that's what a judge needs to do. He needs to be a gatekeeper to make sure people get a fair trial.
Yeah, excellent analysis, Mike. Like I always say, as a prosecutor, you want to try the case to win through the appellate process, not just the trial. They're live in court, so we're live in court. Let's go to it.
Thank you. All right, with the jury out, we're going to play this recording to make sure, is that correct?
Yes, Your Honor, and we have several, these are small snippets of a much larger video, so if we could just walk through all of those, I believe.
Let's go through them all so that we don't let the jury have to get out any more than we have.
Yes. Yes, please.
Is there a way to dim the lights even more? Is that okay? That's fine. Is there a sound to this?
No, Your Honor. Oh, and that's the first video, Your Honor.
All right.
And this is the second video. And that's the conclusion of the second video, Your Honor. This is the third video. And that's, and that's the end of the third video, Your Honor. And this is the fourth video.
Latonia, as a person who's worked as a prosecutor, like all three of us have, as a matter of fact, this case is interesting to me too, because it underscores something that I don't think the public often gets an opportunity to listen to, and that is police officers are trained that the number one way they are not coming home is in a motor vehicle stop. It is the most dangerous thing that police officers do, and in many instances may explain that ratcheted sense of self-preservation when they're pulling a vehicle over. This case certainly is a case in point. What are your thoughts about that?
I think without a doubt, and I think also you actually get to see the encounter on some levels. And that's not something that always happens, but this is an example of when, it goes wrong. And the reason why sometimes officers are very, very concerned, because like you said, and like we all know, that the number one dangerous encounter is going to be that, on the side of the road encounter traffic stop. And this is one of those examples.
Yeah, and issues of non-compliance exacerbate that issue here in a certain sense by him saying, I can't open my driver's side door, which I think is going to be a big factor in the penalty phase here. The police are then put in a very difficult and draconian position at that point in time, because now they're losing control of the scene. Would you agree with that?
I agree with it. I mean, there's so many other things too. Also, with this, is very calculated. I mean, there's a difference between this fight or flight, and then someone who is consciously taking the time. I mean, you had the prosecutor tell you that Sergeant Baker was still alive when Wiggins gets out of that car and shoots him, executes him, and then to go even further, to do all of the phone calls and trying to impersonate him, and then to set his body on fire. It's just such a disregard for humanity and life that we saw in this case.
Okay, let's dip back into court and see what they're doing now.
Regarding what state Ms. Castro-Miles was in, her demeanor, all those things that were going on, which are in no way relevant to the facts that the state is intending to prove, which is the car was was reported stolen, and that essentially that Mr. Wiggins gets in the car and takes the car. That's video 2. I think that's a different story if they're trying to prove that he took the car. So he had the car. But video 1 and getting into the substance and digging down into whatever the circumstances were that led to that, I think it's our position, are irrelevant, and they're unduly prejudicial, and again, it triggers 404B, and again, it leads to an issue where I think the jury's confused.
I had previously issued a ruling on this that I found by clear and convincing evidence that this situation and these facts were in fact clear and convincing. It appeared to me to be relevant to the whole story as the reason that the encounter between the victim and the defendant and co-defendant on May 30th, when the car was still listed as stolen. That was my original ruling. I see no reason to change that. I note the defense's objection to it. I don't see anything in particular in the video that would indicate to me that there was any reason why there would be anything. Whatever the first video was very grainy footage, and I don't believe it to be anything that would be prejudicial per se. All right, anything before we bring the jury back?
So for clarification, Your Honor, all 5 of those videos fall under your ruling.
Correct. All 5 videos will be allowed as evidence.
Thank you, Your Honor.
Bring the jury up.
And the still photo, Your Honor, as well. And the still photo that we showed as well.
All right, jury coming back in gives us an opportunity. Mike Koribanics, judge, like you said, seems very seasoned. What I love about it is he also knows the standard with regard to the motions. He knows what 404 is. He talked about clear and convincing evidence. Can you talk to us a little bit about what did that mean when the judge said clear and convincing evidence, so our audience understands that?
Well, it means more that the judge actually put it through a standard. He wasn't just like saying, it's a 50-50 call. It's a little bit over. No, he's saying, I see this in the context of this trial, and it's clear and convincing to me that this is relevant testimony, that this is essential testimony. And I think his rulings just really make for a very strong record for any court reviewing.
Yeah, Latonia, what do you think about that? I don't disagree with Mike. I'm curious about your thoughts about it. And the judge knows there's 3 standards: preponderance of the evidence, clear and convincing evidence, and proof beyond a reasonable doubt. So he's almost like telegraphing on the record to the appellate division, I know what the standard is, I evaluated it, And, clear and convincing evidence is where we're at. It kind of gives a judge a little credibility boost in front of the appellate courts down the road. And it's definitely going to be a conviction, it seems to me, on the guilt phase. What do you think?
I absolutely agree. And one thing I will say is that he's very impressive. He obviously seems like he's somebody who's had some trial work. And he also knows, like we all know, in a death penalty case, those are very high stakes with regard to appeals, and the fact that there will be an appeal no matter probably, especially if the death penalty is ultimately given to this person. So he is making sure the record is perfected, and he's doing a very good job about it.
Yeah, we can never underestimate the fact, and I know both of you guys know this, that when a judge makes an error in the guilt phase, the defense makes an argument, if there is a death penalty conviction, that the error made in the guilt phase bled over into the jury in the penalty phase. So the death penalty cases I've handled, the judges have been very careful to make sure the defense's rights were protected for purposes of appeal. So listen, guys, great commentary. Really appreciate it. We're going to take a quick break here on the Law and Crime Network, and we will be right back. All right, witnesses moving quickly. While we were on break, Lear Bonsanur took the stand as a motel clerk who called 911 on the defendant. Let's go live.
Okay. And the next video, please. Ms. Monsignor, can you again identify what this video is?
It is the defendant leaving the room.
No, identify the date and
Oh,
the
I'm sorry,
time at the top, please.
5/29/2018, 7:58:48 a.m.
Okay, so this is a few minutes after the previous video. Ms. Bonsignor, there appeared to be another person, a new person in this film that was wearing white. Who was that?
Me.
That was you. And where were you walking to?
I had walked to the room because I thought that her brother was coming to pick her up. That's what I was told.
Okay. And when you walked down there, can you describe who you encountered?
The defendant.
Okay. And can you describe the conversation that you had with him?
I didn't know he was the defendant at the time, but I thought it was the brother, and I just said, "Oh, you're moving out? Well, take care. Everybody do good. Good luck."
Okay. At any time, did Mr. Wiggins identify himself at that point as Mr. Wiggins?
We need you to make a verbal response, ma'am.
Oh, I'm sorry.
That's
Sir.
fine.
No.
Okay. And the last video, please. And Ms. Bonsignor, if you could read the date and the time of this video, please.
5/29/2018, 8:01:35 a.m.
And again, that's just a few minutes after your encounter with him.
Yes.
Okay, thank you. Your Honor, we would move all 5 of these videos as collective exhibit number 9.
All right, collective exhibit 9. Exhibit 9, what's that?
Just make it exhibit 9. It would be exhibit 8, CAD report with 7.
Oh, I'm sorry, Your Honor. I have not entered that.
She hasn't entered that yet.
I wonder if I could
All right.
approach the witness.
We'll mark this as exhibit 8, the videos are exhibit 8, the still photograph that we're about to deal with is next.
Ms. Monsignor, I painted you a photo. Is that the same photo that's up on the screen right now?
Yes.
And is that a still from one of the videos that we had just looked at?
Yes. Thank you.
And we'll move this as the next exhibit.
This will be marked as exhibit 9.
Now, Ms. Bonsignor, you said that when you went back down to the hotel room to check, you believed that her, Ms. Castromal's brother was there. Why did you believe that her brother was coming?
Because a man had made a phone call to the office inquiring about Ms. Castro, if she was okay, if the police were still there.
All right. Nothing further on.
Any questions?
No questions.
Thank you, ma'am. You may be released.
Thank you, Judge.
Thank you. All right, ladies and gentlemen, at this point, I think it's appropriate to us break for lunch. So we're going to go ahead. I think they're bringing your lunch in for you, so we will allow you to go to the jury room and have lunch. It is 12:25. Let's break for lunch until 1:30. 1:30. All right. All right, ladies and gentlemen, let me just remind you again that although we've started the evidence and you're hearing some of this testimony, your duty is not to discuss this.
All right, Ms. Bonsignor, up on the stand, motel clerk encountered the defendant at the motel, identified Mike Koribanics, some of the video at about 8:01 a.m. It starts off, video shows the defendant drive off. A basic piece of evidence that the prosecution needs to show in order to give the jury a timeline, Mike?
Yeah, they need to give the jury a timeline. They also need to give a context. You know, they need to see what events led up to this tragic event.
Yeah, Latonia, what are your thoughts overall about how the state's case is going in so far as from a prosecutor's point of view? I think that's the at least second witness that the defense smartly has no questions for.
Oh, definitely smartly. It's going very quickly, especially when the first witness was his widow. I thought the defense was smart in not asking any questions. And this is a fast-moving case, without a doubt.
Yeah, well, it'll be interesting to see how far they go. Of course, ladies and gentlemen, this is about the penalty in this case. It's a foregone conclusion. There will be a capital murder conviction, but what will the sentence be is what the issue is here. Aggravating factor, at least one of them, is that it's the death of a police officer in the performance of their duty. That's in most states that have the death penalty, a major aggravating factor. We're going to take a quick break here on the Law and Crime Network. But stay with us because we'll be right back. And welcome back to For the Record. So they are on break for lunch. Very quick moving trial in Tennessee versus Stephen Wiggins for the shooting death, 6-time shot, Sergeant Daniel Baker, who was 34 years of old. The incident occurred on May 30th, 2018. The defendant was arrested on June 1st, 2018. Dixon was a 15-year veteran of the sheriff's officer, former Marine. The jury was picked in Knox County. However, they're going to be bused to Dixon County, and this jury is also sequestered. So today, the case is moving pretty quickly. It's a death penalty case. It seems pretty much that the defense has fallen on the sword and said, look, we know our guy did it, but it's really going to be coming down to a question of whether it's life or whether or not it's going to be the death penalty. Let's listen to a little bit of the prosecutor's opening statement, which by my estimation was only 11 minutes long, but by our guest estimation as well as mine, pretty effective.
Sergeant Baker collapsed on the ground, still alive. The defendant exits the vehicle out of the driver's side door, which he had previously said was broken. He approaches Sergeant Baker and at close range executes him. This is on video. The defendant immediately takes possession of Sergeant Baker's patrol unit 500. We will refer to it as Unit 500. He moves the car near Sergeant Baker's body. He opens the rear driver's side door, loads Sergeant Baker's body into the vehicle. Now the passenger, Erica Castro-Niles, runs away from the scene. She is not a part of this trial. This trial was State versus Wiggins. He loads Sergeant Baker's body in. He begins driving away from the scene, at which point the defendant, pretending to be law enforcement, answers multiple radio calls from Dixon County Central Dispatch. He's thinking clearly and quickly, and he responds, 10-4, one in custody, en route, Dixon County Central. Other law enforcement officers on that shift overheard some concerning radio traffic. They also heard a voice that they did not recognize to be Sergeant Baker's. So they began calling on the radio and cell phone. As the defendant was driving away with Sergeant Baker's body in the rear of the vehicle, the defendant answered Sergeant Baker's cell phone, a call from Deputy Chris Lashley. And he tells Chris Lashley, pretending to be Sergeant Baker, 10-4, everything's okay. You will then see that the defendant drives to the Bear Creek Valley area of Dixon County, Tennessee. And he exits the roadway and he drives through a couple of fields to a remote area that can't be seen from the road. He gets out of the vehicle. He steals Sergeant Baker's backup weapon, which is his personal weapon, a Glock 357, and a knife belonging to Sergeant Baker. He takes Sergeant Baker's duty weapon, a Glock 9mm, pops the hood, puts that weapon, whether intentionally or by accident, we don't know, leaves that weapon under the hood of the vehicle. The defendant then sets fire to Sergeant Baker and also the front seat of the car. He closes the doors, locks the doors, and flees.
Latonia, this was an 11-minute approximately opening statement, but the prosecutor goes into very specific detail, not so much about the shooting, but about what happened right after the shooting with regard to the vehicle, the body, the weapon, the getting on the dispatch call and saying one in custody en route, picking up the officer's cell phone and trying to deceive fellow officers who don't recognize the voice on the other end. I cannot help but believe that this is going right to the heart. This prosecutor is not thinking about the guilt phase. He knows he's got that locked and loaded. He is looking at the penalty phase when the mitigating factors that the defense will try to argue about mental health illnesses or potentially any other mitigating factor, that this was a purposeful, cold-blooded, something he had said before the murder occurred, that if he ever got pulled over by the police officers, that he'd take them out. He actually commits the murder. He actually goes to a very elaborate cover-up, so he knew exactly what was going on mentally. What are your thoughts about how he did, and do you agree with that theory?
Oh, I absolutely agree with that theory. He was able to show how calculated Wiggins was in this whole entire encounter. Not only was he calculated when he got the officer to go around the way he did of the car and then shoot him, he gets out of the car. At that point in time, he could have possibly left himself, but he gets out of the car, shoots him at point blank range, executes him, and then is trying to cover his tracks. I mean, it's just very elaborate for him to even think to do that, and for him to be thinking that quickly. If supposedly it was almost something that was, a quick thought process. No, it's something he's thought about, and it's definitely about the penalty, because there's no mitigation when somebody's cold, calculated, and on some levels evil when they go and they take a life like they did in this case.
Yeah, right, Mike. No explanation that would mitigate the conduct, which pushes it towards the death penalty. And even that piece about, oh, my car door won't open, so that and thereby the cop has to say, okay, get out the passenger. Again, another very calculated. It seems like from the beginning he was tactically oriented. That's what the prosecutor said, to put himself in a better tactical position to shoot the cop. That's not a good fact either for the defense.
Well, it's very difficult, and it's very difficult when you hear it in context of the videotape we saw, and you also hear about when they were when his girlfriend was in a problem with him, when she had to run to the motel office, and how he wasn't under the influence of drugs, he wasn't under the influence of alcohol. So this jury is slowly seeing and building up to the conclusion that this was a, for lack of a better term, evil person. He had no problem moving every step of the way to murder someone and just continue on with his life. And that's the scary part. And I think it's very strong the way the prosecutor's doing it, because it's sort of just building up, and it's going to keep building up throughout this trial.
Yeah, interesting. So let's listen to a little bit more of the prosecutor, who in a very short but sweet opening statement is nailing the coffin down as far as what he's doing to the defendant in this case.
Ladies and gentlemen, you will see proof that after fleeing the scene, one of the largest manhunts in the state of Tennessee occurred. And for a little over 2 days, the defendant was at large. But he was captured and arrested. And when he was arrested, he was found in possession of the murder weapon, a .45 caliber semi-automatic high point, which was ballistically, scientifically confirmed to be the murder weapon. He was also found in possession of Sergeant Baker's backup weapon, the Glock 357, and Sergeant Baker's knife. Upon his arrest, he was taken into custody, but first taken to the hospital and checked out, where the doctors found that he was just dehydrated. After he was rehydrated, he voluntarily interviewed and provided a statement to the TBI, which you will hear and see. In that statement, he was asked, "Why did you walk up and shoot Sergeant Baker in the head close range?" And the defendant said, "It's like a dog. You don't let it suffer." Ladies and gentlemen, this crime is on camera. The defendant has confessed. There's scientific testing, fingerprints, DNA, ballistic testings, all to confirm and reconfirm that the defendant committed these crimes. You will also see a video test by the TBI of the Saturn, where they demonstrate that the driver's side door is fully operational from the inside and out. The state's proof will show that the defendant was lying when he said the door won't open. The state's proof will show that the defendant set up Sergeant Baker, forced him to go to the passenger side, where the defendant could get a tactical advantage and await the moment to shoot him while he was unsuspecting. Not only that, ladies and gentlemen, you're going to hear from a witness in this case that earlier in the month of May, the defendant said, "If I'm stopped by law enforcement, I will smoke their ass." at the conclusion of the state's proof, I'm going to come to you and ask you to find the defendant guilty of every single count, because this case was proven not only beyond a reasonable doubt, but beyond all doubt.
All right, Latonia, let's get a little practical here. Let's get real. We all know that the courtroom is a place where you can have laws and you can have rules and regulations, but you know, what a jury does and the psychology of a jury could be a completely different thing. In fact, we hear that term jury nullification, where jurors know that the evidence is solid, that the person is guilty, but because of some emotional reason, they feel they understand contextually or whatever, and they come back with a not guilty verdict or a hung jury. But in this case, the prosecutor, again, effectively did something here that I think stops any possibility, if there were even that one juror who may be recalcitrant about the death penalty and having handled death penalty cases as a prosecutor, always worried about that one who says they can impose it, but in the end really can't. And that is the statement that he gives to the police, the defendant. It's like a dog, you don't make it suffer. This is like just an unappealing thing, unsentimental, horrible, evil, disgraceful, despicable, flip response by the person who just killed somebody. I can't imagine, I gotta be honest with you, from this standpoint, if all of this evidence comes out undaunted like it has so far, this guy escaping the death penalty. We're in Tennessee here.
You know, I would agree with you, but you know, stranger things have happened. I mean, I'm here in Atlanta, and we've had a case where a person killed 4 different people. It was the courthouse shootings, and he killed the judge, he killed the court reporter, deputy, and then time away kills a federal officer. But still, the jury found, for purposes of the death penalty, they didn't impose that. And so you never know what may happen. As the state, you still can't take for granted that, as horrific as the facts may be, that it is a gone and given conclusion that person will indeed be, you know, given the death penalty. But in this case, I mean, as you stated, as the prosecutor has stated, it is pretty cold and calculated, and that he didn't even give the type of humanity to this man. He said it's like a dog. You take it out of its misery, but there were other ways you could have ensured that there was no misery by not even starting this whole entire sequence. And that's something to be thought about in this case.
Yeah, and sure. I mean, you know, anything can happen, but so far, from what we're hearing in the opening statements and the manner in which the witnesses are going in, you know, as lawyers, we're always evaluating our case from witness and even sometimes question to question. We drill down so deeply. And Mike, one of the first witnesses they called in the case was his wife. I did that once in a homicide case. It was very, very effective. There was a reason for doing it because she was part of finding the defendant in the case. And man, showing the pictures of this police officer who was being analogized by the defendant as being a dog, with his getting his weapon for Christmas and being with his little girl for tea time. I mean, that is a great start in your case, and you want that first witness to be a wow witness. So that's a pretty, for between the opening statement and the first witness, pretty much of a wallop to the defense so far, no?
Absolutely. I mean, it becomes, Bob, this case, when he was given the opening statement, I was saying, is this going to be a 2-day plea? I mean, is this really a trial, or are they just going to admit guilt and go on to the next phase? However, once you put his widow on the stand, it became so humanized. It became so touching. I mean, you know, she laughed. You could see she was holding back tears and sadness as she spoke, but she still had the power to smile about how her husband had touched her life. You know, he told her what she wanted for Christmas. She'd go out and make fun, and they'd have a laugh at Christmas, and she's not going to have that anymore. And that touches a jury.
Yeah, for sure. The emotional component is so important. Well, you know what, Mike? I'll tell you what. We're going to take a quick break here on the Law and Crime Network while they are out to lunch. And let's play a little bit of that Christmas video on the other side. We'll be right back. All right, we're in the case of Stephen Wiggins, charged with killing a police officer, a sergeant, in fact, and testimony going in very well for the prosecutor. We were just talking about before the break, the impact of your first witness, so important: primacy, recency, every witness strategically placed in a spot so that the jury understands as best as possible what you know in your mind. Can you get it out to them? First witness called by the prosecution is the victim's wife. Gave some riveting testimony with respect to a Christmas present, and we have a Christmas video that was played before the jury. Watch.
Why? Wait, for the record, what did you say you think it is? No, you said... Whitney helped me with the packing.
Who did?
Whitney.
Holy crap, she paid the box there. Jesus Christ.
Don't cuss. I'm gonna show this video to people. Now move the big box out of the way. It's a decoy.
Is that a gun?
Open it and see. I don't know. That was a little too easy to get in the box.
Holy crap. Oh my God.
Silence is probably not a good thing.
I don't know what to say.
Well, was that not what you wanted?
I don't know what to say.
Is that not what you wanted?
Yes.
Is it not? It's not the one you
I'm
wanted?
trying not to cry while you got me. Hey, turn the camera off.
Wow, Latonia, I mean, how powerful the love between the wife and the husband, and her explaining that she knew he wanted that weapon and she went and got it, that she did subterfuge to hide it so he would think it was something else. And then, I don't know, I just had this image in my mind of him being like a little boy at Christmas time with his legs crossed and opening the box and him just looking at it and staring, so happy. Man, very, very powerful, that humanization rather than the antiseptic courtroom. I think that's going to go a long, long way with this jury to conviction and death penalty sentence.
Listen, it's one of the most powerful things that the prosecution could have possibly done. It humanized him. The jury hears his voice. They got to see him alive. And then also implied in it, he celebrated this Christmas with his family, and he's not going to have any more Christmases with his. They're not going to have any more of these memories. And the reason they're not going to have any more of these memories is because of the cold, calculated actions of Wiggins. And that right there is just so powerful. I don't even know. I've been a defense attorney. I don't know how you get past those types of pieces of evidence.
You just took the thought right out of my head, Latonia. I was about to turn to Koribanics because he's got his bow tie on. He's looking really good today, as always. He's all spiffy. All right, Mike, put yourself in the defense's position here. I know that when I was trying death penalty cases as a prosecutor, the defense used to say, keep him alive for another month, another day, another hour is a win. Is that pretty much where he's at right now?
Yeah, well, Latonia pointed out, this was so powerful. And I give a lot of credit to the defense attorneys because it really takes a discipline not to cross-examine, because you always feel like you have to do something to show your client you're working for him. But the skilled trial attorneys know when to leave people. And there's this witness too, Bob, as Latonia was speaking, came to mind, and I think this may come to the jury, is what exactly she bought her husband on Christmas was something to make sure he was protected. So she was contributing to protecting her husband by buying a gun that he said he needed as a backup. So that really has another tone to it, where it shows that this person was not just some police officer who's nondescript who was killed at the side of the road. This was a family member, and his family members loved him.
Yeah, Mike, that is a great, really, really good point. that I think the prosecutor can make something of in summation. Guys, listen, we're going to take a quick break. Latonia, I know you got to go. It was great having you. Hopefully you can stay longer next time, but Mike Koribanics will stay with us. Please don't go anywhere. We'll be right back.